Ridley Scott's The Last Duel follows the events that led to one of the last judicial duels in medieval France, which took place on the 29th of December 1386, making it this year's unlikeliest Christmas film. The Last Duel was based on a real event, which was recorded by chroniclers of the time, such as the French chronicler Jean Froissart, and explored in the 2004 book The Last Duel, a true story of trial by combat in medieval France. The book, written by the medieval literature specialist Jager, is a thorough and well-evidenced account of the duel, even if, by his own admission, Jager is happy to fill historical silences with the inventions of his own imagination. But the 1386 duel was not actually the last duel in France, not even the last judicial duel, although it was the last one to take place before a 1409 ordinance which decreed that trial by combat had been abolished in all courts except for the Parlement of Paris. The last judicial duel to be approved by a court on French soil was actually in 1455, taking place between Jaquetin-Pluvier and Mahiot-Coquel under the jurisdiction of the town of Lancienne. At the time, the town lay in the domain of the Duke of Burgundy, who considered himself a sovereign prince and thus exempt from the ordinances of the French king. And duels for honour, distinct from trials by combat, continued some time after this, with the last legal French duel for honour occurring on the 10th of July 1547, when Guy Chabot de Jarnac duelled and killed François de Vivonne. This was not a duel intended to establish a verdict in the context of a crime, but to restore Jarnac's honour after Vivonne had insulted him. And illegal duels held to restore honour continued to take place in France for so long after that we actually have footage of the most recent one. It was held between the French politicians Gaston Defferre and René Ribière in 1967. Defferre, a socialist, had stood up in Parliament to shout "Taisez-vous, abruti!" or "Shut up, stupid!" at René Ribière, and Ribière had demanded satisfaction via a duel. The duel, which took place the night before Ribière's wedding, saw Ribière cut twice on the arm before it was brought to an end, as Defferre had vowed he would not kill the younger man before his wedding. I suppose that would have been ungentlemanly. But back to judicial duels. What was it about them that led to their demise? Well, Jager himself explains how they came to an end in France. By 1200, the duel began disappearing from civil proceedings in France, while in criminal cases it was increasingly limited to males of the nobility. In 1258, Louis IX eliminated the duel from French civil law, substituting for it the enquête, a formal inquiry involving evidence and testimony. But this still left the duel in place, as a last resort, for a noble seeking to appeal his lord's verdict in a criminal case. In 1296, King Philip IV completely outlawed the duel in times of war, because judicial combats amongst the nobles sapped the realm of manpower needed for military defence. In 1303, Philip outlawed the duel in peacetime as well, but Philip's nobles resented the abolition of their time-honoured privilege, and 3 years later, in 1306, the king relented, restoring judicial combat as a form of appeal in certain criminal cases, including rape, but now only under the king's direct jurisdiction. The 1306 decree was still in force 80 years later when Jean de Carouge went to Paris to appeal Count Pierre's verdict, but by now judicial duels were extremely rare. 4 strict conditions had to be met for a case to qualify for a duel. First, the crime had to be a capital one, such as murder, treason, or rape. Second, it had to be certain that the crime really occurred. Third, all other legal remedies had to be exhausted, with combat, proof by one's body, the only means of conviction left. And fourth, the accused person had to be strongly suspected of the crime. So, after the 1386 duel, there were few further judicial duels in France. However, this was not the case for all of Europe. England likely saw its last judicial duel in 1456 between Thomas Whitehorn and James Fisher. Whitehorn, in order to escape his own execution for theft, had accused Fisher and other men of the same crime and agreed to fight them should they claim they were innocent. Unfortunately for Whitehorn, Fisher did claim his innocence, and so the two fought, as the 15th century Gregory's Chronicle records. And then the defendant rose up and him and said, "My quarrel is as faithful and also true as my belief, and in that quarrel I will fight." And with the same words smote at the peeler, that his weapon broke. And then the peeler smote a stroke to the defendant, but the officers were ready that he should smite no more, and they took away his weapon from him. And then they fought together with their fists long time, and rested them, and fought again, and then rested again, and then they went together by the necks, and then they both with their teeth, that the leather of clothing and flesh was all to rent in many places of their bodies. And then the false peeler cast that meek innocent down to the ground, and bit him by the members, that the silly innocent cried out. And by hap more than strength, that innocent recovered up on his knees, and took that false peeler by the nose with his teeth, and put his thumb in his eyes, that the peeler cried out and prayed him of mercy, for he was false unto God and unto him. And then the judge commanded them to cease and hear both their tales. And the peeler said that he had accused him wrongfully and 18 men, and besought God of mercy and of forgiveness. And then he was confessed and hanged, of whose soul God have mercy. Ireland saw their last trial by combat even later, on the 7th of September 1583. It took place between two members of the O'Connor clan, and it's recorded in the State Papers of Ireland. The first combat was performed at the time and place accordingly, with observation of all due ceremonies, as so short a time would suffer, wherein both parties showed great courage by a desperate fight, in which Connor was slain and Tague hurt, but not mortally, the more was the pity. And the last trial by combat in the British Isles, and possibly all of Europe, that we're certain definitely happened, occurred in Scotland on the 15th of March 1597. Adam Brumfield accused James Carmichael of murder, fought, then slew him. But why did trial by combat die out? Jager again gives us some idea. In the earlier Middle Ages, people of all social classes could resort to judicial combat, and public duels took place among peasants and townfolk as well as nobles. In parts of Europe, even women were allowed to fight duels against men. The duel was used to adjudicate a wide range of felonies, as well as civil cases such as property disputes. In the later Middle Ages, however, judicial duels became more rare. Popes denounced the duel as a tempting of God, a thing forbidden by Scripture, and kings frowned on trial by combat because it infringed on their judicial authority, which they were trying to wrest away from their powerful barons and consolidate around their own thrones. Indeed, we have numerous examples of trial by combat skeptics throughout the medieval era. Liutprand, king of the Lombards from 713 to 744, wrote, "We are unsure about the judgment of God, and have heard of many men who have lost their cause unjustly through trial by combat." In the 9th century, the Archbishop Agobard of Lyons said that the duel was opposed to Christian charity, to reason, and to experience, which teaches us that the outcome of duels is often unjust and wrong, and which is confirmed by many examples from Holy Scripture, showing that even the just man can be defeated in battle. Finally, the duel was opposed to the nature of judgment, which consists in wise investigations, not brutal power. 3 centuries later, in the 12th century, the English legist Ranulph de Glanville wrote that the legal institution of trial by jury is based above all on equity. Justice, which is seldom arrived at by battle, even after many and long delays, is more easily and quickly attained by its use. And in 1215, the Fourth Lateran Council under Pope Innocent III forbade, in Canon 18, clerics to participate in ordeals and judicial duels. Neither shall anyone in judicial tests or ordeals by hot or cold water or hot iron bestow any blessing. The earlier prohibitions in regard to duelling remain in force. So, we can see that there was considerable scepticism, even hostility, from many medieval authorities over the effectiveness and desirability of trials by combat, and the Fourth Lateran Council's Canon 18 did result in considerably fewer trial by combats within a generation. However, the 1215 Council did not alone spell the end for the trial by combat. Something else had to change first. The problem with early medieval justice was that it didn't really rely on evidence to convict someone. By far the most common form of proving your innocence was the wager of law, or compurgatory oath. If you could swear to your innocence alongside a number of other oath helpers, men of good repute who were respected in their communities, then you were found innocent. These men didn't have to provide you with an alibi or give any information on the case at all. They simply needed to swear an oath on a holy book or relics that you were innocent. The problem was that not everybody could find that many men of good repute to vouch for them. And if you were a serf, you weren't eligible to vouch for someone, which was a problem if you needed 11 men to vouch for you, and nearly everybody who knew you well enough to do so was also a serf. If you found yourself in this situation, you might prefer the ordeal. These came in various forms. You might have to plunge your hand into a hot cauldron and pick something out of it, or carry hot iron 9 feet to see if your wounds would fester, or be plunged into cold water to see if you would sink or swim. Again, this is not very evidence-based, but when ordeals were banned in 1215, two forms of justice that would become evidence-based were gaining popularity: juries in England and inquests on the continent. These were not immediately as reliable as the modern juries of today. On the continent, for example, 24 oath-worthy men could be summoned one by one and asked to give any evidence that they were aware of to a panel of 4 knights. If 20 of those men could agree on a set of allegations, the case was considered proven. The hazardousness of this probably explains the comment from the Castemol of the Châtelet, the court of the city of Paris, that no one should put himself upon the inquest if he can help it, for there can be great danger, since no one can be loved by everyone. However, it eventually began to fall on the members of the jury or inquest to reach decisions based on evidence. Take this trial in the early mid-13th century, where the jurors had discovered information that the accused's alibi was a lie, placing him on the same stretch of deserted road as the victim of the time of the killing. And on this inquest, we requested a judgment, over which there was great debate, for some jurors wanted to condemn him to death based on the inquest, and others said that, since the fact was not proved by the inquest, he should not die. And the others said he should indeed, for one could not prove murder in an inquest, except by finding the suspect in an open lie, and in a patent presumption of guilt. Whilst they clearly had a long way to go, here we can see the beginnings of the belief that guilt could be discovered by a group of humans examining the evidence. Up until then, guilt had been thought to have only been accessible by the defendant and by God. This growth of emphasis on evidence-based guilt rather than guilt revealed by divine intervention was the background on which Louis IX decreed that matters which had once been tried by duels would now be settled by inquests in 1258. And whilst medieval jurors did not have the capacity for evidence analysis that modern jurors have today, a fault which left room for further trials by combat in ambiguous cases in the centuries that followed, the 13th century, with its growing emphasis on evidence rather than divine intervention, rang the death knell for trials by combat. As medieval courts developed increasingly sophisticated rules of evidence, opportunities to settle legal disputes by duel arose less often and were increasingly frowned upon. By the time of France's last legal judicial duel in 1455, the French chronicler Mathieu d'Escucci wrote of it, "In truth, it is an abominable thing to record, and it seemed to many present that it was contrary to our faith." And when, 4 years later, the Duke of Burgundy, who had been present for that final duel, issued a revised edition of the Customs of Burgundy, he dropped the concept of trial by combat from Burgundian law altogether. If you enjoyed the video, remember to subscribe for future content. And a big shout out to my patrons who help me produce higher quality content. If you want to join them in supporting the channel, check out my Patreon, as well as a list of some of the sources used to make this video in the description below. I'll see you next time.